in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
Buckle up. The judge opens a case. The witness is sworn and the defendant immediately derails the room, calling out that a lie and launching into a rant. This opening is pure bait. It establishes a chaos, the tone, and gives editors a perfect 20 to 30-second hook to shove viewers into the rest of the drama.
Warrant to issue for your arrest back in December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
Here, the courtroom pivots into a service or warrant showdown. The judge reads a bench warrant history while the defendant flatly denies being served, claiming eviction and no notice. It's a compact legal clash. One side cites procedural standards, the other screams inadequate service, or the courtroom tension you need to frame the case's core procedural dispute.
Okay, Miss.
Me under trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that
the judge returns and the defendant doubles down on jurisdictional conspiracies, demanding Article 3 status and insisting the court lacks power. This segment is a classic sovereign citizen moment. Formal courtroom language clashes with conspiracy rhetoric, producing short, high-impact drama that highlights a complete breakdown in ordinary courtroom decorum.
On October 23rd, 2023, there was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail. You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
You do not consent to this PPO, and you must prove and show your oath.
USPS at an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June, so there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial, so you're going to be going to prison under.
After being muted, the defendant keeps firing off constitutional citations, threats, and even death penalty talk, while arguing she was never allowed to present evidence. This clip shows a meltdown crescendo, legal citation salad, threats, and defiant performance paint her as both combative and convinced she's been robbed of due process.
Okay, we don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And I need to
Deputy,
see your
did you hear
own-
me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in
I
judgment.
don't need an attorney. I don't consent to an
Yeah, I
attorney.
can't. I don't have a prosecutor. I need you to come back. What about
I
2:30?
want to say something. You guys are.
Miss
I've
Williams,
Your Honor, I'm talking to
5
you.
days.
I
I've been
have
here for
no
5 days.
prosecutor.
I was
I
not
got
even
you.
notified of this court. I was not even given notice of this court date, and I've
Yeah,
been here.
so-
5 days.
Mr. Ness,
Let's
please
say
be quiet.
1:45. I don't have a
You
prosecutor.
need to
I
be
can't
quiet.
do
This
anything.
is my hearing.
Can we do 1:45, officer?
Yeah, 145.
The bench pauses. Staffing and scheduling become a mess, and the defendant argues about not being notified while the court tries to set a reconvene time. It's a short administrative nightmare that reveals how procedural holes and miscommunication fuel the larger conflict, perfect for showing the practical fallout of the earliest service dispute.
I believe arraignments can take place without the prosecutor's office, but
I kind of thought so. I
Might be-
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
I've been, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-warrant arraignment.
Hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, House Counsel on behalf of.
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And
Certainly.
I'm entitled to relief from judgment under Michigan Court Rule.
The prosecutor finally appears. The clerk calls the case and formal arraignment language returns. Attorneys identify themselves, and the court walks through foundational rules while the defendant insists on speaking for herself. This is the moment the hearing tries to reclaim order. The legal machinery turns back on, and you can feel the tension between procedure and chaos.
I'm going to enter a not guilty plea on your behalf. You'll be given.
I don't consent to plea. There should not be a plea. This should be dropped.
I'm gonna give you a 10,000 personal bond. You can be released on GPS tether.
Well, then I'll just add that to the criminal charges that I'll be filing against you in federal court
Okay.
with the executive order that says that are you or are you not an administrative law judge? Yes or no? Why won't you answer my question? Are you an administrative law judge or are you a judicial judge?
I'll do the 10% on the 10,000.
Are you an administrative? Why will you not answer my questions? I have a right to ask you a question as a public servant.
She can.
Are you an administrative law judge, Regina Triplett? Or are you a judicial officer?
1,000 has been paid and she receives a tether, then.
Your Honor, I apologize for the interruption. However, when respondent was speaking, and I noticed it appeared that you were speaking, the audio did not come through.
Let me ask you this. So what day would you be able to do a trial, Mr. Tudge, on the allegations?
Your Honor, I did, when speaking with the petitioner, it's my understanding that there may be evidence that has yet to be sent to my office. I would believe a period of 3 weeks may be sufficient to receive the evidence, send discovery.
Why is he allowed to, why is a petitioner,
I'll make that a 10,000 personal, but she has to have a GPS tether on.
so why is the petitioner allowed to submit evidence, but I've not been allowed to?
Sineski, I'm gonna release you on a 10,000 personal bond, but you're
What
gonna
does that mean? I don't have money to pay anything.
don't have to pay any money. You just have to show up for court for your next court date. But you will be placed on GPS tether because you cannot violate.
Bond, GPS tether, and a blunt judicial decision land here. The judge enters a not guilty plea on the defendant's behalf, orders a $10,000 personal bond with a GPS tether, and the defendant erupts, threatening federal filings and demanding proof of jurisdiction. This clip contains a tangible consequences, release terms, a tether, and an enraged protest. Heavy drama with clear stakes.
Your Honor,
Deal with that other case, however you deal with it. I've given you a
Okay, but I'm here and I can't get out. That's why I'm asking you what address, because I'm not going to be able to get there.
Your Honor, may I just say this? We're going around in circles. May I just request that we just need a date, that's all. Because
Can I just get the discovery sent here?
Court Williams, I was just given a date 1 second ago. I was waiting. So May 27th at 9 a.m. will be your next court date. You have that, Mr. Tudge, Ms. Fort Williams?
Yes, Your Honor.
All right, so we'll see the parties back on May 17, 2020.
No, you said 27, right?
27. I apologize.
Okay, thank you.
At 9
Sure.
a.m., okay?
Your Honor, is
So
this
why is
a-
it okay for my rights to be violated? I want to know, why is it okay for you to violate my rights?
Ms. Sineski,
I want you to prove jurisdiction. Prove that you have jurisdiction over me. I'm doing a quo warranto. I'm demanding a quo warranto, and you have to prove jurisdiction over me.
Gonna get out with tether. You'll be able to access.
It's not about that. This whole entire matter is void ab initio. So you have never proved jurisdiction over me from the beginning.
To say something. Go ahead, Mr. Tudge. You got to get it out.
Your Honor, is the matter scheduled for a trial or a final pretrial?
Let's schedule it for a final pretrial.
so that's May 27th at 9 a.m., Ms. Sineski.
Yes,
Thank
and
you so much, Your Honor.
Tudge, you can get whatever discovery or whatever you need. Contact Ms. Abrams, and at least we'll know on that you have everything.
So the thing is, though, is that I'm doing a jurisdictional challenge right now, and you have to prove jurisdiction before this can move forward under Michigan and federal laws.
Your Honor, she has the date. So is this concluded?
Yep.
Ms. Sineski has the date.
The court sets the next dates while the defendant continues to challenge jurisdiction and rail at the judge's authority. Scheduling, discovery directions, and a jurisdictional demand collide in a final flurry. It's a classic wrap-up shot where the judge attempts to close and the defendant refuses to relent. A closing beat that leaves viewers hungry for the next episode. If you like this breakdown, smash that like button, hit subscribe so you don't miss our next video, and we'll see you in the next one.